Way back in the late summer, early fall of 2012, there were some press accounts that Obama and the Environmental Protection Agency, working hand in hand, had produced all these extremely radical and controversial regulations that were going to cost you billions and billions of dollars, but they were going to hold back on them until after the presidential election, because as we know, the leftists don't want to be held account at the ballot box. And so seeing that, Landmark Legal Foundation filed a Freedom of Information Act request seeking really basic information. We wanted to know what regulations they'd been working on and were holding back. We wanted to know with whom they worked, what outside groups, what departments and agencies, anybody at the White House. Because you see, ladies and gentlemen, these regulations are supposed to be objectively pursued without politics, without ideology. But as you well know, they're not. And so we sought this information, and we've never received this information. It's almost 2 years now. And we've taken all the steps through the FOIA requirements, through the federal court processes, to get the information. We went to federal court a few months after we filed the FOIA request, and we asked the federal judge, a superb federal judge, Royce Lamberth, to issue an order preserving all potentially responsive information at the Environmental Protection Agency, because our experience with the EPA back in 2003 told us they won't preserve that information. As a matter of fact, they were held in contempt by this very same judge because of serial destruction of emails, serial destruction of backup tapes of emails. Now, remember, folks, this is a public agency. This is public information. You paid for this information. This is a federal law, the Freedom of Information Act. It exists so you can have access to information related to these bureaucracies and agencies. You're not supposed to be a second thought or a non-thought. You're supposed to be involved in this if you choose to be or if organizations choose to be. And yet this administration operates in the shadows, behind the scenes, with their friends in the nonprofit world, in the environmental world, in the radical world. And you and I are apparently not permitted to know what's going on. So when we went to federal court, to the judge, and we asked for an order to preserve all this information, the Environmental Protection Agency represented under oath that such an order wasn't necessary, that they were going to take the steps needed to preserve potentially responsive information. The Assistant U.S. Attorney said the same thing. And based on their representations to a federal judge in a federal courtroom, that order was not issued. As time went on, it became increasingly apparent that the Environmental Protection Agency was dragging its feet to get past the election. They were hiding regulations and a regulatory process that they did not want the American people to know about. And we were not getting information. And the information and the arguments being made by the EPA and their Assistant U.S. Attorney were conflicting. They were disingenuous and worse. So we asked the federal judge in another filing, we would like to conduct discovery on the adequacy of this search, the nature of this search, on the preservation of the documents. And in a very unusual ruling, Judge Lambert said, you're right. Based on our hearing and based on the information I have, you have legitimate questions. So we allowed the Landmark lawyers to conduct several depositions, to issue sets of interrogatories. And among those deposed was now the former administrator of the Environmental Protection Agency, Lisa Jackson, the deputy administrator, who's still there, and several other individuals of consequence, but not so much for this discussion. And to make a long story short, ladies and gentlemen, the administrator of the EPA at the time, Lisa Jackson, her files were never searched. She used an email, a private email, to conduct a lot of her business. That email address was cleaned out. She also conducted business by texting on her cell phone. Those were never searched, and her cell phone is missing. We asked the Environmental Protection Agency to go to Verizon and try and recover whatever data that they could. The Environmental Protection Agency basically blew us off. We're unaware of what kind of search has been made for her cell phone. It gets no better when it comes to the deputy administrator and others who were the subject of the FOIA request. This has been going on for a long time as they drag it out and drag it out and drag it out. But you see, you have to set the predicate when you're litigating. for motions that you file in front of a federal judge, and you have to prove your point, because the benefit of the doubt goes with, unfortunately, the federal government and the bureaucracy. The evidence is now overwhelming and uncontroverted and unequivocal that the Environmental Protection Agency has destroyed an enormous amount of data and information related to its conduct with regulations prior to the presidential election, related to the nature of its conversations with a variety of organizations and individuals, and that information is likely gone forever, although we are uncertain of that. So today, in an extraordinary filing in front of this federal judge, we have filed with Judge Lamberth with an enormous amount of backup exhibits and so forth. I request that the court find that the Environmental Protection Agency has, as we use this term I've used before with you, spoliated evidence and information. It failed to preserve data that was the subject of litigation, that its representation to the court, that it was in fact going to preserve the information, was false, and for this it should be punished. For this, it should be held to account. Now, among other things, we are asking the Environmental Protection Agency through the court to grant our motion for sanctions. That is, we're asking the court to impose this on the Environmental Protection Agency because of their engagement in spoliation of agency documents and document-containing repositories. We're asking the court to designate an independent monitor reporting to the court and the Landmark to be paid by the EPA to assure that neither Landmark nor any other person who has legal activities going on against the EPA, that none of us be denied our right to the preservation of agency documents and litigation, and to direct the EPA to promptly collect all remaining responsive documents under our initial filing with the EPA. We're asking the court to command that the EPA employ whatever resources are necessary to complete this in 30 days. We're asking the court to direct the EPA's Inspector General to investigate and report to Landmark on this in this matter to the court within 30 days on all spoliation issues involving each and every senior official covered by Landmark's FOIA request. And we've also asked the court to direct that the EPA review its docket from 2009 to present and send a notice to every single plaintiff and petitioner, every single individual, organization, business, what have you, that's had legal interactions with the Environmental Protection Agency, that the EPA be required to inform each and every one of the real possibility that the EPA engaged in spoliation in their proceedings. This, among other things, is what we've requested. We have filed our motion and our brief and our exhibits with the court today in federal court with Judge Royce Lamberth, who's a superb judge. He will make his decision. We will await the outcome, and I will keep you informed. But it's not the IRS alone that is involved in the business of destroying records, of ignoring the law, of concealing its activities, and giving false statements. The Environmental Protection Agency, which is a litigation machine, needs to be held to account. And I will be damned if we're going to close our eyes to what they've done. Listen to this story from the Daily Caller, Michael Bastosh. White House to release $34 billion in new regulations after midterm elections. So this is the pattern. In 2012, the Obama administration was heavily criticized for delaying major regulations until after the presidential election. A new report by regulatory watchdogs found the White House may once again be delaying major regulations that are expected to cost a total of $34 billion. The American Action Forum reports the White House is set to release 15 major regulations totaling $34 billion in costs until after the midterm elections, and a significant amount of these regulatory costs come from energy and environmental regulations emanating from the EPA. So this is the imperial president, this is the totalitarian mindset of the left of the Democrat Party that I've been talking about for ages now, on display. The regulatory process is supposed to be open to you. The Freedom of Information Act is supposed to make sure you get timely access to information involving decision-making within the massive federal bureaucracy. The purpose of elections are to ensure that You have an opportunity to vote for one party or another, one candidate or another, based on the public record and based on their public positions, not positions that they release the day after the election. And so everything this administration does is intended to thwart republicanism, little r republicanism. Everything. While the president today is running around talking about patriotic economics or economic patriotism, the left is so moronic. Economic patriotism, he says. Well, then let me suggest what the president is doing is economically unpatriotic. Is it not? And if what the president's doing is economically unpatriotic, that makes him unpatriotic. Since when is socialism, centralized big government, patriotism? This is how the demagogues change our language, change our words, and change the arguments. This government is driving this nation into massive bankruptcy, the consequences of which are unimaginable. So what does Obama do? He focuses on a relative handful of companies today and makes that the issue. And if it's not that, it's contraceptives. And if it's not that, it's something else.